Okay. Yeah, so as I said just before we started to record, this session is the first session for the Queen Mary University of London alumni networking chapter. And our first topic will be arbitration and cybersecurity. And we will concentrate on the matters related to the how cybersecurity affects arbitration procedure. We have together with us two prominent speakers. This is Ms. Claire Morel de Vesgava. She is partner with Brian Cave, Light and Pesna, and she has lots of things to say on the cybersecurity issues and the arbitration as well. And then we have Wendy Gonzalez, who is Dispute and Litigation Counsel at ASUS, and she is also the person who founded Cyberarp, the organization about which she will talk herself, and I think she will get us some insights on that. So without further ado, I think I will give the floor to Claire first to tell a bit about herself and about Silicon Valley Arbitration Mediation Center. And then we will turn to Wendy, and then we will basically open floor for the discussion of the arbitration and cybersecurity issues. Okay, Claire?
Thank you. Thank you, Victor, and thank you to Queen Mary and Cyberarp as well for collaborating with this this event. So I was asked to tell you a bit more about a group which I'm co-chairing at the moment. So this is the young professionals group of the Silicon Valley Arbitration and Mediation Center. So the Silicon Valley Arbitration Mediation Center is an organization that promotes the use of arbitration and mediation for technology-related disputes. And the young professional groups, which I'm co-chairing, is a group for professionals up to 40 years old. And we look at different things as part of this group, but the two main themes that we are interested in are technology disputes and how this can be resolved by arbitration and mediation or mediation. And also we look at generally the intersection of technology and arbitration and the use of technology and sometimes the impact of technology on arbitral proceedings. So I just wanted to mention one thing about this group, which is that at the moment we have a few positions on our steering committee that are open. So I'd invite any of you who are interested in those themes, in those topics, to first become members. Membership is free. If they're interested, they want to engage more with people with common interest, but also potentially also consider this call for applications, for positions on the steering committee. So that's what I wanted to say about this YP group.
Thank you, Claire. So now floor to Wendy, and Wendy, hi, please tell us a bit more about yourself and about Cyberarp.
Sure. And first of all, thank you to Victor, Claire, and everyone organizing this event today. I can say that Cyberarp is an initiative, a bit pandemic initiative. That's how we start. It's a multidisciplinary team, international, of course. We have legal people, tech people, and we try to meet in the middle of cybersecurity and international arbitration. Actually, two of our executive members are here, Carolina Mauro and Karina Albers. So we are trying to work together and raise this awareness on cybersecurity. Of course, trying to provide practical guidance, moving away from the theory, but getting hands-on and get practical tools for everyone, and of course, promoting the debate that we are having today. For example, this initiative is something we really promote and we really support. So that's a bit about Cyberarp. It's growing, it's getting bigger, and we have Claire as one of our great supporters next to Sofina Pert and other practitioners. So willing to help on this project all together, of course. Thank you.
Thank you. Thank you. Okay. Now I will proceed to our questions, which is like basically our main part of this event. And as I already told, we are going to cover cybersecurity and arbitration. The topic is really big, so we will concentrate on several questions which are the hottest at the moment and which are, how to say, bother arbitrators, parties, institutions. And I think as Wendy is the founder of Cyberarp, it makes sense, Wendy, if you start with the some like very general question, how to protect parties, arbitrators, and institutions from cyber threats. And the idea of this question is how advanced are the measures which are already at the, like I say, used by the arbitration practitioners, and also how many measures at the marketplace are available which could be used by the arbitration, those participating in arbitration.
Sure. And I think that something we do in Cyberarp is to make things very practical. So let's imagine that cybersecurity is like a house. So we need to protect everything in the house, not only the garden, not only the main entrance, which might be, I don't know, the arbitral institution. We also need to protect every door, every window in that house. So that's the main idea behind cybersecurity. And as Claire well knows, any weak link is the one that can create a threat at the end and a potential attack. So having that in mind, the measures that should be taken, they should be taken at all levels: physical, logistical, administrative. So it's a job of everyone. What has been happening is that this pandemic is basically increasing, accelerating what was already an ongoing digitalization of the industry in general. And that's, of course, making cybersecurity even a more relevant topic nowadays. So it is true that one of the most relevant initiative and one of the most relevant documents that we have is the 2020 Cybersecurity Protocol. It was drafted by the ICCA, the New York City Bar Association, and CPR. So that's a great initiative. That's already a really good preparation and summary of all the cybersecurity measures in international arbitration. We have seen a lot of guidance coming from arbitral institutions about virtual hearings, for example. But from my humble opinion, I think that this is not enough. It is not enough yet, because there is some discussion already. For example, the new LCIA rules, they already mention some aspects on cybersecurity. The ICC, not for parties and arbitral tribunals on the conduct of hearings, they already mention cybersecurity, information security. However, what we see is that there is a gap. We need practical tools. We need to understand how to make this theory of cybersecurity measures to make it practical. And when we talk about measures, is since this notebook that I have now with me, making sure that I have the required software that is updated, that I have a camera that is covering, that I have a proper network. All these tools, all these steps is something that we need to take. And I think that we might discuss it later, but it's not only one person's job. I think it's everybody's being aware of the situation and taking the proper measures. I know that maybe we as lawyers, we want to make, black and white list, A, B, C, D, this is how we need to do it, period. It's not how it works. So in my case, coming from a technology, more like a technical background, a technology company, I can see that it's not something that we can fix and that's there forever. No, it's evolving, it's changing. Before, phishing attacks were happening only via email. Now they can also happen on social media messages. So this is evolving, and we cannot just look for one set of rules that can save us all. I think might be not enough, from my humble opinion, of course.
I just have a small follow-up question, Wendy. Is it like you mentioned rules, and do basically institutions like LCIA and ICC, they decided to make it parties problem, or did they instead invoke some technical guys who advised them how to better, like how to make this trend, and maybe they already suggest something to the practitioners? Is there something on that?
Yeah, so far we have Article 30A of the 2020 LCIA arbitration rules. So it is mentioned that the tribunal, by consulting, with the parties, they should take measures on information security. So it is a step. I think it's already one step ahead. But then the question is how to make it. How far shall the tribunal go taking these measures, and how to take it, basically? Shall they do it themselves? Shall it be the arbitral secretary? Shall it be the... I know that Stockholm survey on virtual hearings, there was a proposal about a technology secretary or something like that. It was one of the ideas raised. Shall it be that tech person on the secretary, maybe? Shall it be at source, maybe an ODR platform? I don't know. So that's maybe an open question now.
Yeah.
Victor,
Yeah.
I think Wendy raises an interesting point here. So far, the position of institutions, if we set aside the institutions that are providing online platforms, so far the position by the institutions and also the organizations that are that have set up those task force that have come up with some guidance have sent a message that this is very much an issue for parties to discuss and to identify a potential risk and come up with measures, with the tribunal, being part of this discussion and ultimately coming up, with a measure. So deciding if parties can't agree on a certain measure, this is something that the tribunal should do. So that's fine, that's their position, but that raises a few problems. One is that arbitrators haven't been trained to identify cybersecurity risks, and they haven't been trained to identify measures, technical measures to address those risks. So if we look at the problem from a more from macro point of view, is the solution that the parties and the arbitrators are responsible for this a good one? That's a question mark. That's the first issue. The second issue is that tribunals, they're only there for one case, right? We all know that at the end of the case, the tribunal, its job is over. The tribunal, the parties' jobs and counsel's job, everything is over. It's just a one case. And so addressing cyber risk just on another basis for every single case, again, is that what we want as a community? Or are there any measures that could have a systemic impact on the level of cybersecurity across the board? Perhaps not across the board, covering the entire arbitration community in the world, but for example, we can think about measures that could have an impact on the level of security across the board of, for example, all the arbitration conducted under certain rules. Can we not raise the level across the board as opposed to just deal with every single case on a case-by-case basis?
Claire, may I just ask you, like, this basically was what I was just going to ask, saying now, but there was a BCLP survey, yeah, and you actually, I think, inquired into these issues, and I might be wrong on figures, but I think half of the respondents said that this should be tribunal problem, and only 20% decided that it should be problem of the parties. Or am I mixing up and it's another way around? And anyway, my question is rather.
Hang on, because I need to correct you. Keep
Yeah.
in mind what you want to say, because it's actually the reverse. So 48% said that it should be the parties who handle cybersecurity risk. Here again, we're facing the same issues. Parties, the in-house lawyers and external lawyers, they're not cybersecurity experts. So 48% said the party should take the lead on that. 31% said it's a problem for the institution. Okay, that's good. Maybe we can go down the route of systemic measures here, but the problem is that we forget all about the ad hoc cases that are not administered by an institution. Okay, and then 21% said that it should be for the arbitrators to handle. And I've got another data which is interesting. To me anyway, among the respondents who sat as arbitrators, nearly half of them said that it should be the parties themselves that should take the lead on that. So I thought it was interesting that quite a low number was achieved for all respondents in terms of the arbitrator's responsibility, but half of the people who sit as an arbitrator said, no, it's not my problem. And you can see why. Arbitrators is like judges. They haven't been trained to identify risks and come up with measures. And I think they feel very nervous about being responsible if ever they came up with a measure that was not appropriate.
I mean, Claire, just as far as I already understood your position, you think that institutions should take the lead, yeah? And it makes sense because they are marketplace leaders in arbitration. They conduct, like, some of them hundreds, some of them thousands cases per year, yeah? But anyway, if we try to, like, put it around, yeah, and ask ourselves, arbitration is consensual in nature, and basically when parties agree to opt for arbitration, they opt out courts, they opt in something much more expensive and efficient, they think. But again, now businesses conduct this, let's say, now marketplace is very isolated to the pandemic, yeah, and businesses know that they need to conduct business from New York to London to Moscow, from different places, and they have many effective protection measures. So what I'm asking is, maybe parties themselves, at least sophisticated parties, should consider that litigating, arbitrating, like basically arbitrating any dispute which arises in future is just the continuation of their usual business dealings, and they should approach it in the same way and be able to provide facilities. What is your stance on that?
I mean, facilities may be a kind of, it may be difficult because, again, as it's just a one-off, right? An arbitration is a one-off. Even big companies that have arbitrations all the time, which is the a minority of businesses, right? They will have, for each case, the counterpart will be different, the arbitrator will be different, the institution might be different. So it might be difficult to come up with a solution that works for all the cases. But I agree. I'm not saying though, but that it's not everyone's responsibility to try to raise the level on a systemic basis, but also for in everything we do, and that's why I think this is where Cyberarp can really help in educating us lawyers who are not technician, cybersecurity technician, to improve our hygiene in terms of IT infrastructure, sending emails, sending documents via the FTP sites. This is something that everyone should pay attention to, and I definitely welcome initiatives such as Cyberarp for that. They can do that. They can also come up with some kind of protocols as part of the cases, and I'm talking about counsel, I'm talking about arbitrators, that may not, those protocols can be practical, and the more practical, the better, probably. They can also work with institutions who might be able to provide, as Wendy said, some technical assistance, which could be tailored for each case. And they can also come up with some kind of protocols in terms that are not that technical, but that at least will provide some guidance and some potentially contractual terms as to what, who's taking the risk there. So, for example, I can give you an example of a provision that could be inserted in terms of reference or terms of appointments. For example, you could have something that says each party will be responsible to take reasonable steps to actively protect arbitration data, for example. That doesn't give you any guidance as to what you're actually supposed to do, but if there is an issue along the line, at least we have something contractual to anchor a potential claim, right? Because we need to think about hedging risk and managing risk and reducing them. We also need to think what if that happens. Under all data protection regulations, there are obligations on parties to notify a breach. This is very clear. In the arbitration sphere, we don't have, it's not very clear what regulations apply to which arbitration, and we don't even know who would have jurisdiction to resolve an issue, a dispute that would arise out of a data breach in arbitration. Would the tribunal that was in that case competent to handle that disputes? There's a lot of questions for before, or to avoid the data breach, but also lots of questions as to after. How can we prepare in case there is a breach?
Yeah, thank you, Claire. We actually have a question from the audience, which bridges good with our discussion. I think Wendy might want to address it, or I don't know. I will read it first, and then we will decide whether. Okay, so basically, Karina Albers asking, don't you think that every stakeholder, including the arbitrators, should be responsible for their own cybersecurity, as nobody has control over every email and document repository? In the end, I believe that the responsibility will be outsourced to online arbitration platforms and document repository platforms and hearing centers. So, Wendy, if you okay, I will ask you to address this one.
Yeah, exactly. At the end, this is a bit what we should all keep in mind, and I really think that when we think about, we try to debate on cybersecurity, we also realize that it's not something that is affecting our industry in arbitration. Is also affecting other industries. And yes, it's everybody's job. Every stakeholder should be responsible at some point. The question is how to define this responsibility. And of course, maybe some arbitrators might be more careful than others, and maybe using a specific platform for emails and maybe others not. So this is something to keep in mind and how to measure it. But at the end, it is also interesting that there are on the market already online dispute resolution platforms. So they exist and they are already there to support on some aspects. They might help on the exchange of communications. So maybe avoiding the tribunal to send WhatsApp messages during the proceedings, not because WhatsApp, it's just, I'm just saying one platform, just to say an example, but it's something that we need to keep in mind. It's a popular platform, it's something that we use on a personal base. Then why should we use it for proceedings? Because it's easy. Okay, not necessarily means that, it's appropriate. Then we have these platforms that can maybe encrypt all the files that we put on their server. They can even have their own systems to check potential threats coming up and down. So it's a tailor-made solution. I understand that some parties and in some proceedings that might not be the case, or maybe they don't want to use it. But then we need to think how to define who is who and what to do. From Cyberarp, what we are doing, and this is maybe a spoiler alert, I can say here, we are about to launch in a few days a template on a procedural order for cybersecurity. So the idea is that this document, it's a template. We want to have it ready for arbitrators and parties to be able to have a basic, 1-2 pages document to start a basic setting on cybersecurity on the procedural order. Of course, it's going to be the very first edition, and we are happy and we welcome all feedbacks and all comments because we want to make this a joint effort. So evolving, improving, modifying, I think that's a team effort. And happy to receive comments on that, which is coming soon. So people who is in this webinar, at least you know that this is coming in a few days.
Okay, Wendy, just to follow up briefly, because as I'm listening to these issues of protecting against cybersecurity threats, I think only question which comes to my mind that why there is still no answer, because we cannot address fair and direct question, who is to pay? So could you provide maybe some examples from like practice, how parties actually approach that, and in which cases, like maybe institutions agreed that, okay, we will bear these costs, or maybe like in several disputes, parties effectively agreed that, okay, we recognize cybersecurity threats, we should maybe bear the costs, we should maybe buy a license of this platform for this specific dispute. So just maybe some practical examples.
Yeah, I think that of course Claire can share more than me, having many more clients. I have one client, of course. Okay. Working as in-house, I only have one. And being a technology company, of course, cybersecurity is our first priority, and we know that we are on front line. So every day something might happen. Every day there is a threat. And it's not only us, it's for any technology company. So we know it, and we are facing this on a daily basis. But that means that what we expect from our external counsels, what we expect from the arbitrators, the mediators helping us, is to have, the basic understanding. And maybe some arbitral institutions, I can say, they are willing to listen. I know that, for example, Stockholm, Madrid institution, they are having this ODR platform. So they are willing to listen and say, okay, we have this platform. Here you might have some extra measures, but of course, it's not enough because I am working from home, for example. So I don't have the digital infrastructure that I have in the office. So I had to accommodate, and I had to spend time on accommodate a proper infrastructure on this working from home situation. And who knows when they will open the office in the Netherlands. So I really hope they can open so I can go for a coffee again with my colleagues, but nobody knows. And nobody knows how this pandemic will evolve. So we need to be there. So yes, and of course, maybe Claire can go further because she has more clients than me in this case.
Claire, would you add something?
So, I mean, the way it works in arbitration is that at the moment, every entity is looking at its own risk, but there's nobody who's saying, okay, we have this risk, how we allocate it. So law firms, for example, they act as counsel in a case. Law firm have they have their own policies. They train their people. They have all their IT infrastructure, which of course, thank God, all the employees use and benefit from, including when they act as in arbitral proceedings. It's the same for clients. The problem is that when those stakeholders communicate and exchange data, right? So I can give you an example. Once I was acting in a case that's related to a data center. So my client was a data center, a major data center company. They offer colocation services, hosting, the customer servers, but also they actually have a cybersecurity consultancy, right? So they know the threats, they know the issues. I was acting in this case where there was no data breach issue. In this case, it was it was nothing to do with that, and I needed to have, as you have in all cases, you need to have your clients provide you with documents. And I can't remember which platform this person suggested that we use to send documents, but it was highly insecure. I can't remember if it was, I'm not going to say any words, but any names. And then I said, no, you can't send documents on that platform. I mean, it's kind of common knowledge that it's not secure at all. So what we do as a law firm, we have a system. So when we receive documents from clients, we send them a link, and they use that FTP site that we have, and everything's fine, everything's secure. But had I not been aware of that risk, I would have said probably, yeah, that's fine. You can send there. You can send those documents via this platform. So it is a tricky situation. I mean, you sound like it's surprising that we haven't come up with a common strategy and measures, but it's difficult because you're dealing with all those entities, and within those entities you have different individuals who, some of them are not aware of the risk. Here in this example, it was a business person at this client. It could be an arbitrator, it could be an expert, it could be a witness, it could be a translator, it could be a transcriber, could be a tribunal secretary, could be many people. And as Wendy says, when we work from home, the risk are enhanced. But what I'm very grateful for, following the pandemic, is that people are definitely more aware of the risk and that they used to be before.
Thank you, Claire. It seems to me that cybersecurity adds more mess to arbitration. We usually had just like, different laws applying to the arbitration seat, arbitration agreement, to the contract parties concluded, personal laws of parties, etc., etc. And now we also have compatibility issues between different stakeholders. I think I will proceed to, sorry.
Maybe something on that is that there's a new trend. We're going to talk about the platform trends, but another trend which is very specific to arbitration is that at the moment there's a new kind of factor that parties are considering when they're nominating arbitrators. It used to be that the most important factor was experience. Sometimes people could talk about gravitas. Here, the sector has always been important. Here, we often wondering, is this person going to be able to manage the proceedings from a procedural point of view, but also from a technical point of view? And I think that that's quite interesting to see that for many reasons. But one of the reasons why I think it's interesting is that I think it offers great opportunities for the new generation of arbitration practitioners and arbitrators, because the new generation has a lot to offer, in my view, in this area where arbitration and technology collide, and they can hold themselves as understanding better the risks than perhaps the older generation can. So I think it lets, we can also see that from a positive stance.
Yeah, and I totally agree with Claire there. I am a positive person. I think that this is for good, what we are facing. And I have to say that particularly there is a lack of qualified people on technology, on cybersecurity, and even the gap is bigger for female profiles. So that's needed. So that's the future, and we actually need that. And I can say that what Claire said is an example of how a council should properly receive the documents and exchange the documents, this is consequence of a good training. And good training is not only for us in this industry, but good training is also up there in one of the big tech companies. And just briefly, to don't bother you too much, I can say that, for example, the SolarWinds cyber attack, one of the biggest one in the last month. So SolarWinds, basically, they were able to identify this attack because there was one employee from one of the partner companies, so not even from SolarWinds, one of the many, because it's a supply chain attack, one of them was able to identify that the multi-factor authentication, which is, this message that you get on your phone when you are trying to connect and put the passwords or these type of things. So one employee realized that there was something bad about this. So, and this is because this employee, of course, they are engineers and they have more technical background, but still they had a proper training. So having this around, a proper training, understanding what is a multi-factor, why I shouldn't get a request to update my password again if I have already an app. These kind of things, these are the ones that can change and can make the difference, I will say.
Wendy, just a small follow-up on that. Yeah, I will just, I was thinking about that. Anna, do you want to join discussion if you have something to ask?
Could I just ask something?
Yeah.
It's one thing to know about technical matters and things, and another thing to take responsibility about the platform. Confidentiality is something very crucial in an arbitration. So why can you guarantee any platforms that are 100% secure? That's the first question. And if there isn't such a platform, why should an arbitrator or the parties or the institution take the responsibility? Because if they do take any of them the responsibility, then surely we have another line of business, that of insurance. Then we will need something like platform insurance, something to cover the claims and all this and that. So you can understand that, the matters are multiple. I mean, it's not one line of matters actually being a genius in technology or anything like that. It's a matter of what you technical people can produce, and if you can guarantee this 100% security. Thank you.
To be honest, I will limit myself to a very technical reply and the legal part for you, Claire. So if you agree, it does not exist 100% security in this field. So when we are talking about cybersecurity, it's not possible to have 100% guarantee that nothing will happen. Even if you ask the most prominent developer engineer, they will tell you the same. It's not possible. So what means is that we only mitigate the risk. We try to reduce the impact. That's everything we can do. As lawyers, I know that we have this feeling of, there should be 100% solution. There is not. I can say that I'm working very close with the National Cybersecurity Center for Spain, which is working and collaborating with the European one. And we know that it's difficult and there is no way to guarantee it. However, we work really hard to mitigate and reduce. That's at least my humble opinion again.
Okay, so basically what you're telling me now is that you cannot guarantee that. So, in case that something goes out from an arbitration room, then definitely somebody said something. So this is the credibility of the actual person, but actually having to get on the shoulders of an arbitrator or the parties the failure of a platform, then this, you can understand, is a little bit too much.
Yeah, and I have good news. At least in Europe, there are good news. There is a new European directive coming on cybersecurity, so they are willing to make steps. And exactly and precisely cover the concerns that that you are mentioning. So it's coming. Now they are on the drafting phase. It's a proposal, and they are trying to make this, at least for Europe, to make a more, you know, clear structure. What to do if I am diligent enough? Then why should I take responsibility? It might be maybe if I'm negligent. So this type of thing. So it's coming. It's not here yet, but it's coming. And that's maybe all from my side.
The one thing that I was really happy with these iClouds and iThings and whatever is that we wouldn't have to store all these documents in our storerooms, you know. But I mean, it's one thing to actually store all the documents that are going to be the evidence, the written evidence in an arbitration, and another one to actually guarantee the oral evidence that somebody is going to give in front of you. So, I mean, you know, I think that there are many things to consider. I mean, I don't know. I mean, I would be a little bit, not that I don't like, I love technology and I use it a lot, but I don't know if I would take that much of a responsibility in an arbitration, because basically I would have to get on my shoulders things that I'm responsible for other people. Do you know what I mean? So it's a bit.
Yeah, I think, and I think this is exactly the position that most people take. So it's not an unwillingness to look at the issues and do your best effectively to address those risks, but ultimately there is I think a general sense that this would be too much to for example to declare an arbitrator negligence because they came up with a wrong measure. So what we do, we once we appreciate that it's impossible to guarantee that no breach will happen, I think what we need to do is to think about, you know, still think about the risk in a way where we can hold people responsible down the line if there are, and, you know, including by setting up, you know, appropriate insurance policies. But insurance is not the only solutions like that. I think that, you know, there's an array of solutions where we can help ourselves for future in case there is a breach. So just to take your examples as an arbitrator, one of the things that I'd like, you know, Wendy knows that I feel very strongly about this, is that again, let's say I sit as an arbitrator too. I don't feel I'm able to understand if my IT infrastructure at home is appropriate. Let's say I don't work at a law firm, which I do, but let's say I'm a sole practitioner. Why don't we come up with a system where I have somebody come to my office, check everything, check my infrastructure, and give me a certificate? That would be a way for you to say down the line, okay, this is too much for me. I can't be responsible for this. So I just put on the responsibility, as you do in every single transaction. What you do is that you give the risk to somebody else. So you would be able to say, if there is a breach and that somehow that relates to your system, that you actually did your job. You had your infrastructure checked, and this is not you who should bear the consequences, but it's this company that came and that audited your systems that confirmed that was secure. So it's what we do. It's same for disputes that arise out of data breach as part of an arbitration. Notification. At the moment, there's not even an obligation on a party that has been the subject of data breach to notify the other side or the arbitration or the arbitral tribunal. So those are the kind of obligations that can be put in place, and I think should be put in place. So we also mitigating, you know, legal risk in that way, right? We need to limit technical risk, but also legal risk. If we don't even know where, what would be the recourse in case an arbitration, well, let's say arbitral deliberations are hacked, for example. At the moment, no rules tell us what we should do. And at the moment, the obligations are very unclear. So I think it's one way to mitigate the technical risk, and the fact that we are not able to guarantee technical risk. Well, no, we are not able to say no risk at all. Then we have to look at legal risk and how we allocate those.
Yep, totally agree. Totally agree with Claire.
I wanted to make a small follow-up just to colleagues, just to try to understand what changed actually. If we take a step back, like maybe 15 years back, when all the papers were sent not electronically even, and electronically was really something like unusual, and they were stored, let's say, in some special locked room in the institution. The question is, if some evidence could be missing from the institution, stolen, lost, or whatever, whether institution will be responsible for the parties, for arbitrators, for providing not really good service. Do you know any about that? Is it like maybe it never happened, or maybe if it happened, it was settled somehow because it's strictly confidential usually. So Claire, I don't know if do you have some examples on that?
So you're exactly right that things haven't changed that much. There was always a risk that somebody leaves a bundle behind in the bus, and I'm sure it happened. Thank God it hasn't happened to me. So we fall back onto the key principles here, right? I mean, if you're an employee, your company will probably take responsibility for that. There may be insurance negligence, director and officer, insurance policies in place. If you're a sole practitioner, you would also need to have an insurance in place for not only the work you do as an arbitrator, but also when you advise clients. That's an obligation, under the relevant ethical rules. And the obligation to take to have an insurance policy in place for arbitrators has been there for a long time. Nowadays, those arbitrators are advised to check that those policies include and cover for cyber risks, but which is not always the case. So then they're advised to check that, but there's always been this requirement for insurance policies to be in place. So some of those, some of the older or the protection, if you wish, that were already in place will assist, and we can fall onto some of them. It's just that they need to be adapted a little bit.
Okay, thank you, Claire. Wendy, we have a new question from the chat, and most likely it goes to you. I will just read it out, and we then may decide. Veronika Pavlovska asking, thank you very much for insightful presentations. Is there the way to help individuals, independent arbitrators, secretaries, translators, and others, and small law firms who do not have sufficient resources to provide high level of security equal to the large law firms or institutions to improve their security? Should we as a community develop some guidance for individuals and small enterprises how to use the available platforms in a more secure way? So Claire, Wendy, who wants to start or to address that?
Yeah, sure. And good to see Veronika around. She's one of our rapporteurs in Cyberarp. So I know she likes the topic a lot. And actually reading your question and reading the question itself, I do realize that we are facing the same problems that other industries are facing. So we are not the only ones. What I can say is that there is a national working group for the ISO on cybersecurity. One of the, let's say, initiatives that are now under debate on the working group that I'm supporting is that we need to have proper training not only for the developers, for the engineers, but also proper training for non-technical people, lawyers, translators, any other profession. So let's say that with that, we are facing the same problems. And we need to remember that at least in Europe, there is a the main workforce in Europe are small and medium enterprise. So they are the majority. And of course, as Veronica is saying, maybe they cannot have a 25 people IT department. So how do they do it? So first, training, I think, is something that is coming. I am part of the working groups, and we are really working and pushing for that because we believe that everybody should be able to understand. No matter which is their position, they should have a basic knowledge. And second, certifications. So the idea of Claire is something that we do for the fire alarms, right? So you have a building, someone is coming, they will check the fire alarm, the system, they will check all the settings, they will make sure you have everything, and they will give you a certificate saying, yeah, if there is a fire alarm in this building, you are covered. Here's a certificate, you comply with this. So that's maybe something we need to start doing to make sure to have a certification. Of course, this is a difficult step. It's not easy, but I think we need to partner with other organizations in other industries, because I know it's happening for some industries. So we just need to connect and maybe go out of the bubble of arbitration and ADR and partner with them, maybe Cyberarp and Silicon Valley, these organizations. Maybe we can try to make the bridge and help to get the connection. And of course, discuss that maybe we don't need the same certification as, I don't know, like a specific profile, but we need a type of certification. So that's something we can work and is coming. And I think we all are going to be forced to take action, at least in Europe, because this proposal for European directive on cybersecurity is coming. So I think that once you have one of these directives, you are kind of forced to take action. Same as GDPR, nobody was paying attention. So now we start to take action. So a bit like that, I think, is going to happen. And not only Europe, more are coming. So that's also interesting.
But Wendy, but what do you think on the like first practical steps? Because what comes to my mind, because I'm working as well in IT company, and the first week which I joined, I participated in the tutorials how to avoid phishing emails, how to, I don't know, do not leave your laptop without password enabled, etc., etc. So. So what should be the lowest standard for somebody who is at least somehow involved in arbitration from like your point of view?
Yeah, so at this point we are now, I will say that we need to have a passive training and also an active training. So passive is the example you gave. So we normally get these trainings and maybe we do it every 2-3 months because that's something that changed. So we need to update ourselves. So it's passive. We receive it because we are lucky enough so to have a company that is, training us. However, if we don't have the resources, we also can have an active training. And nowadays, I can say that there are many national institutions. So if you go for your national cybersecurity institution in your own language, you can see that there is guidance, videos on YouTube, 2-3 minutes, how to avoid this. Do you know that this is something we need to, just as we try to to learn a bit on on politics or global warming and COVID, so we try to educate ourselves. This should be also part of our general knowledge, so yeah, something to keep in mind. And you go to your national institution. I'm very happy because I can read it in Spanish. So it's the Spanish National Agency. They have amazing material. So I invite everyone to look for their national one. And if they don't have it, there is also the European one, which is quite big. There is a one in America. So it's there. We just need to be a bit more active, I will say.
Thank you.
And of course, follow Cyberarp, of course.
Before we proceed, I think I have one more question from the chat, which seems to be about our discussion right now. Just give me a sec. Yeah, questions relates to the ISO obligations. Acts merely as a fiduciary agency regarding to the voluntary feature of this institution, how they can provide trustworthy platform which have legislative meanings to ensure the cybersecurity. So maybe Wendy, maybe you can shortly comment. I think it comes to the same thing, which is how to say, question comes around how far. They just basically provide guidance, I suppose. So maybe you add a few words on that.
No, I mean, basically ISO as their national versions, because they also have their national versions, they create this international standard. So if there is this ISO in particular about cybersecurity, and then as an arbitral institution or maybe as parties, we want to purchase, we want to outsource a particular ODR platform, we can tell them, well, I want you if you can confirm that you have this international standard, this ISO. Or I want this provider because maybe it's the one that can confirm me on this standard. So it's part of the game, I think. So they are setting the standards, and then it's on us to make use of these tools. And how, of course, other stakeholders will do it is a question mark. I think it's too early to make a clear-cut answer, but it's there. So it's still a question mark, I will say.
Yeah, Claire, you're mute.
I agree that it's you know, this is there and we can make use of it. I would also say that arbitral institutions, they have the power to change rules and to require certain standards to be applied or certification. This is an example of this is then when an institution provides a platform, they have some rules that go with that, right? So they have to decide if they make the use of the platform mandatory or not. Some institutions do that. Some institutions still allow parties to not use their platform. They will somehow generate some obligations around that and policies, and that's the case for the use of platforms. But if we go down the line of certification, you can imagine a system by which, for example, an arbitration court, so let's say the ICC court or the courts of the LCIA, will not confirm the appointment of arbitrators unless there is some certification about the infrastructure. Same for parties, same for law firms. You know, you can imagine a system by which, you know, if you want to play, if you want to be part of the game, you have to disclose what you do to manage those risks. And again, there's no expectation that, you know, if you have those certifications or if you confirm that you're taking those steps to, for example, train your people, nothing can happen. But it's just it's a matter of reducing those risks and allocating the legal risks that come with the technical risks.
Okay, thank you, Claire. I think we will make a small how to say transition to a bit different question. We basically discussed already on the technical measure, which also played the game. And Claire, could you provide us some background on the implications of using evidence which is obtained via data breaches?
Is this question to me? Can you hear me?
Yeah.
Okay. I'm sorry, but my connection is a bit patchy. Right. So this is another way to look at the cybersecurity in arbitration, and it is whether one can produce and rely on evidence that has been obtained through hacking activity. And again, this is not a new issue. For a long time, there has been some doctrines and some case law on whether a piece of evidence that has been obtained illegally, may not have been via hacking, but another illegal activity could be relied on. So there's some national laws on this, and I'm going to mention a recent English law case on this issue. There are some doctrines, and so when the issue arises in arbitration, depending on the law, the governing law, those legal systems may be relevant to this question. Ultimately, it's an open question, and I think arbitrators, tribunals are ultimately going to have their say and decide on those issues, because, as you know, under virtually all legal arbitration regimes, it's the arbitrators have the power to decide all evidentiary matters. So I just wanted to mention on that. So this case, this is the case of Ras Al Khaimah Investment Authority versus Azima, which was decided by the Court of Appeal here in England in March this year. And so in this case, it was an appeal made by a person, Mr. Azima, who had been found liable for dishonesty. And so he appealed on the basis that the findings, so the ruling of the first instance court was based on emails of himself that had been obtained by way of hacking activity towards his email. And so he said, as a result, the evidence has been obtained illegally, and so therefore the evidence should have been excluded, not admitted, and the claim against me should have been struck out. And the Court of Appeal refused and dismissed the appeal on the basis that first of all the emails were relevant to the claims of dishonesty against him. That's one thing. The second thing is that because it was relevant, those emails would have been disclosable anyway, so he would have had to produce them, even if they were obviously harmful to his defense. And so on that basis, the Court of Appeal said no. And also I think the illegality, so the hacking activity, the fact that the emails had been obtained in that way was disputed, I think. But regardless, the Court of Appeal said that even if illegally obtained, relevant evidence should be admitted. So it's quite an interesting development. And I just wanted to mention this doctrine of the fruit of the poisonous tree, which is very old doctrine. As I said, it's been it's not only relating to hacking, but it's been developed over the years, I think, in the US, and it's basically this idea that you cannot actually rely on evidence that's been illegally obtained. It's a doctrine that it's a principle, and there are exceptions to it. So it doesn't necessarily mean that this decision of the Court of Appeal here in England, is against that doctrine. But I wanted to reinforce the fact that it is interesting to see that this case law is not new. It's just that the circumstances of those activity that are illegal, that through which evidence was obtained, are new, fairly new. But the concepts were existent, and we can rely on our respective legal systems to find solutions, to offer solutions.
Claire, small follow-up question. Am I correct if, like in this case, for example, the evidence was, like, correspondence was privileged? and then disclosed via hacking and placed before the judges. Does it seem to be that judges will reach like opposite conclusion?
This was the decision made by the Annexed Tribunal in the case of Libanenko versus Turkey. In that case, the responding state had allegedly been surveying, so observing emails, privileged emails between the claimant and its counsel and experts, I think, and the tribunal refused to look at those emails. Of course, I mean, there would be two reasons for this, right? The fact it's privileged and the fact it's been obtained by illegal means. The tribunal kind of got around that question, did not really say, which one was which, but ultimately the emails were not produced. They didn't have to be produced.
Okay, thank you. So I will just address this to audience. If anyone would like to raise some questions, please do, because we covered what we intended to cover and discussed, as I may recap maybe briefly, both technical, organizational, legal measures, both idea of how tech and arbitration meets each other, yeah, and what should we do now with that, and hopefully our speakers gave us some new insight on that. But if you do have some additional questions, now it's time to raise a hand and to put it in, because otherwise we will briefly give closing remarks and close our discussion. So while we're waiting for the questions, maybe Wendy, Claire, I will ask you for some like closing remarks.
Thank you. I mean, it's a huge, vast topic. It's really hard to provide key takeaways or the bottom line. Really, it's as Wendy said, it's fast evolving technically. It's very much an area where we haven't been trained initially, and so we're trying to grapple with all those questions while the risks are still evolving. But I think it's hugely interesting because it has an impact on the process, on the administration of the arbitration, on legal risks. And so I would maybe finish with that, with what I said earlier about the prospects that those issues bring to the table, and then really encourage people who are interested to find out more and embrace those issues and contribute in a way that they can, and potentially also use this to stand out and seize opportunities for their development.
Thank you, Claire.
Yes, very little to add. Maybe reminding everyone that if we think cybersecurity as a house, we can never, assure that nobody can, get into our house if we're on holidays. We don't know. We never know. We do our best. So that's the idea. We try to mitigate. We do our best. And sometimes, using, training is important, but also using common sense. Do you open the door of your house to any stranger and then you just invite them to your living room, to your kitchen? You don't, right? So this is maybe something to remember. Of course, unless you are asking some delivery food, you might open the door. You need to open the door if you need to order food. But remember that it's something that we need to be attentive, use common sense. Why this arbitrator is asking me to download a PDF if we just discuss it? So why should I do it? And then call and say, are you the one sending me this email? These kind of things. So it's something to be attentive. And of course, it's not difficult, it's not impossible. And we are here to work together on that.
Thank you. So once again, thank you, Wendy. Thank you, Claire. I I hope it was insightful for our listeners, and at least it was insightful for me. Thank you very much for agreeing to speak today, and I hope you enjoyed it as well. And everyone, this was first webinar from the Queen Mary University of London alumni Distant Learning Networking Group. It's really, really long title we have. And I hope we will have more such webinars. Please join Distant Learning Chapter LinkedIn group. Please join Cyberarp. Please follow up the Silicon Valley Arbitration Mediation Center. And thank you once again. And on that note, we closing it. Bye.
Goodbye.
Thank you.
Bye-bye.
Thank you, everyone. Bye.